All right, welcome back to Inside the Law. I'm your host, Philip Holloway. Thank you for spending part of your Sunday with me if you're here live. And of course, if you're watching on replay, whenever you watch, thank you for being here. Of course, today we are going to get into, let's just call it a weekly update of I call it the Fani Willis versus Young Thug trial, because that's what it is. Even though Fani Willis may not be in court, she is the one who brought this case. Her name is on the indictment. The team works for her. And we're going to be talking a little bit today about what that might mean. And of course, we're also going to be talking about what's coming next, because the jury is set to come back tomorrow morning. So before we go any further, let's go ahead and welcome our friend Rachel Kaufman back here inside the law. Rachel, good afternoon. How are you?
Happy Sunday. I'm great.
Happy Sunday to you, too. Let's talk about Brady for just a minute. A prosecutor must, even if you don't ask for it, they must turn over anything that's exculpatory, which means it might point away from guilt. And I'll tell you a personal story that happened to me. I mentioned my busy week that I had. One thing that I was doing this week, among a lot of other things, is I settled a very big criminal case that I've been working on for a couple of years. And you know what helped us settle it, Rachel? I had the prosecutors in the case sit down with me, and they disclosed some Brady material that they had recently discovered in the last few days. Now, it wasn't the kind of Brady material, exculpatory material, that conclusively established, that anybody was not guilty. It did tend to kind of arguably point in that direction. So they're obligated to tell me about it, right? And they have to do, and so they did what they were ethically, legally required to do, because they're honest people. These particular prosecutors are experienced. They know what their job requires them to do, and they came forward with it. And it caused, because it does muddy the waters, so at least from their perspective, it brings all the people involved, the stakeholders, it brings us to the bargaining table, and it allows for a fair compromise. And that's what we did. And it was because, at least in part, because they did their role, they did it the right way, and it caused us to resolve a case in a way that I think was fair. That was not Fulton County, I presume? No, it wasn't Fulton County. Look, the things that we're seeing in this trial, this is not every courtroom. I mean, most of the time, most prosecutors turn over most Brady material. And that's the best way I can put it. I think that's accurate. Sometimes it gets inadvertently left out. Sometimes it gets intentionally left out. And sometimes it is in bad faith, and extreme measures are warranted. But what are your thoughts, Rachel, on this video that we showed of, Prosecutor Love, when she was asked by the judge, look, we're in the middle of trial. We've been at this for months or years and years. Can you think of anything that's exculpatory that you might, or even discovery that you might should have already turned over?
Okay. Well, there's a few problems with this. First of all, as I'm watching it, I watched it live, and then I just watched it again as you presented it. And it's just the pause between the question, and I don't even know if Adrienne even really says anything. I wish I could have seen her face, because the judge is asking a question that really shouldn't even be asked at that point during the trial. I mean, in Georgia, and I feel like it's probably other places too, you have to get discovery 10 days before trial. Providing discovery in the middle of trial is not timely. And any judge who really cares about fairness would exclude it. The reason that all of the exculpatory evidence, whether or not it's going to conclusively show that your client did it or didn't do it, that doesn't really matter. What matters is the fact that the state has the burden of proving beyond a reasonable doubt that it was your client. And so any evidence that would tend to show that it wasn't them, or that it really wasn't possible, or that somebody else could have done it, it's really not for them to parse through, to put aside and only provide if they have to, or if they deem it credible, which is what happened with Copeland, which I'm sure we'll talk about. But I mean, the babying from the judge to the state saying, is there anything else? It's too, if I was the judge, it's too little too late at that point. I'm not asking you to turn it over now. And the fact that they're even doing that, like you're saying, they go to prosecutor camp over the summer. all of us as Georgia lawyers have to get professionalism, continuing legal education hours every year.
Let's talk about Copeland since you brought it up. That's Woody, right? So we know that the defense is claiming some things happened in these ex parte meetings with former trial judge Glanville, who where he made some statements, Woody did, Copeland, that may be considered exculpatory. What were those statements? I mean, it had to do with the alleged murder, right? And it wasn't exactly like it would completely clear anybody, but it kind of like maybe pointed that way if a jury believed him.
Yeah. So the parts of the transcript that we have, and Caleb Bumpus, I think she did her best on the stand to try to explain what had happened. I don't think it became clear to any of us what was actually said by Copeland. It is hard to remember, a full conversation after, weeks and weeks and weeks. But all of that said, Copeland said something or many things to the prosecution in front of at least one prosecutor, possibly also the judge, where he's saying, I have information about this, that it likely wasn't this person, maybe that I did it. And we don't know the specifics because I think it has to do, like you were saying, with the car that was used. Is this Infiniti that was used in a murder? Yeah. Who was in the Infiniti? Yeah, but the issue is that the prosecutor specifically said to him, well, we're giving you immunity from those things. We are not going to prosecute you. Making some comment about it being outside of the statute of limitations, which kind of make no sense if we're talking about a murder, because there is
no statute of limitations for murder.
But it's almost as though the reason, and they, I think Simone Hilton mentions part of the reason that they're going to give him immunity is because they couldn't prosecute him based on him just making an admission. Well, what were the admissions? Then they acted like he didn't actually say anything, and then they got their investigator to get up there and say that he didn't say anything. But he must have said at least something to make them believe that he was involved in some of the crimes that he was. And
he also said, if I take the stand, I'm going to get out there and lie and things like that. And this, I think, in my opinion, points out why one of the reasons why at least the ex parte was improper. I think that despite the judge's ruling, which I'm going to get to here in a minute, she denied our friend Doug Weinstein's, his was like, I guess, the last remaining motion for mistrial that she had not ruled on, but she wound up denying that. We're going to go into that next, but she said in that order that this is not a critical phase of the case. And when I went to law school, we learned that a critical stage of the case is basically anything after indictment. And if the defendant could have benefited by knowing about and being able to cross-examine and ask questions of the witness, this is why it should have been done in open court so they could do that, because I think their due process trial rights, in my opinion, with all due respect to the judge who ordered otherwise, I think that it was grounds for a mistrial.
I completely agree with you. And I don't think that the state, it's very clear in Brady and the other case that you mentioned, Giglio, which I think is important as well. It doesn't matter whether the state thinks that it's a good thing or a bad thing, or whether even they believe him. I get that the prosecutors think that somebody else, including the people on trial, did the things that he may be taking credit for in this ex parte meeting. That's not for them to say, we don't believe you, so now we don't have to tell the defense.
Let's go ahead and dive into this briefly. I'm not going to read all 9 or 10 pages to you, but this is Judge Whitaker's one of the most recent, if not the most recent, ruling denying Kendrick's motion for mistrial. And of course, Doug filed a really good supplement, in my opinion, which we've talked about here inside the law. Anyway, in his motion for mistrial in the supplement, he basically sets forth 4 grounds that it's impossible to redo the proceedings that occurred on June 12th, 13th, 14th, and 17th. That was the period of time between which Judge Glanville should have sent the recusal motion to another judge, and when he did actually pause this case. So he said that is grounds for a mistrial, that the defendant's constitutional right to be present at a critical stage of the proceedings was denied when none of the defendants or their lawyers were back there in chambers for the 2, not 1, but 2 ex partes, that the defendant's due process rights were violated when the predecessor trial judge Glanville aligned himself with the prosecution team by his comments during the in court on the record, ex parte discussion between the court, prosecutors Love and Hilton. It says they allegedly coerced Copeland into testifying. And then, of course, fourth, that the bias of the predecessor judge constitutes a due process violation. I have said in here before, Rachel, and I know you have too, first off, and I want to pause here and get your thoughts. I have what the judge points out in her order here in this sentence, that the defendant is correct. This meeting was about more than the parameters of Copeland's immunity and whether he understood the ramifications, because Fannie Willis herself has filed pleadings signed by her in this case that said that, look, this was just a hearing in chambers that had to do with immunity and nothing else. And I thought at the time that was very disingenuous. And here to read this, it appears the judge agrees with that statement, at least. What do you think?
Yeah. Fannie Willis put in her motion, she said that the ex parte meeting was proper. She underlined it and bolded it as though that was going to give any sort of like, I don't know, it gave emphasis to it. But coming from her, again, at this point, I don't really care what she has to say. But anyways, yeah, she says it's correct that the meeting was about more than just the parameters of the immunity and the potential ramifications. And that's very clear from the transcript. So I'm glad that, what's been very frustrating with this judge is she seems to understand logically that there were major issues, but now she just kind of wants to sweep them under the rug. And I'm not a chef, but it just kind of came to me that like, it'd be like making a recipe. Like you've already poured everything in. You can't take it out.
Right.
And she just kind of like, oh, we'll just add more stuff and hope that they forget that those ingredients that weren't supposed to be in there are in there. No, they're still in there.
All right. So and I completely agree. And never, even though the judge apparently agrees with our assessment that the meeting was more than just a hearing on Copeland's immunity, she says here it was not a critical stage of the trial. She said state, but I think that's a typo. Critical stage of the trial at which the defendant had a right to be present. And she starts out citing a case from 1934 out of the U.S. Supreme Court, followed by a Gagnon case, 1985. And in her footnote here, let's always like to check footnotes because sometimes you can find interesting stuff there. She says, this court sympathizes with Mr. Melnick, that's Copeland's attorney, Jonathan Melnick, his understandable indignation at having his professionalism and his loyalties to his client questioned. The court likewise appreciates defense counsel's umbrage.
Wait, was this after Adam Abadi got on the stand and trashed him and said all these horrible things about John Melnick, who I saw the other day in court? And I told him, whatever this judge is sympathizing with, she let Adam Abadi, who is also her former colleague, who she's like, yeah, we were, they're probably friendly outside of the courtroom. And she allowed him to get on the stand and, in my opinion, do just as much damage, if not more, to Mr. Melnick's reputation in a way that was completely unprofessional and outrageous and irrelevant.
Well, I saw John in court too this week. So he's been all over the place. He's a busy guy, and it was funny. I'll tell you this little. The judge called his case, and he has a conflict. And when attorneys have conflicts, the judges will they'll get a conflict letter from us. They know that we have multiple places to be in, and they will hold for us to come in and make a report. And we have to report in a certain order, and this is all quite normal. So just because a lawyer's not there at the time the case is called, it's not a big deal. In fact, if you have a lawyer that's busy, that's got any kind of business, he or she's probably got multiple places to be anyway. And John Melnick was no exception. And so when someone said that he was in Fulton County, another lawyer said, Judge, he's trapped in Fulton County and it doesn't look like he's ever going to get away. And everybody in the courtroom, just including, well, I won't say who all, let's just say everybody laughed because everybody is aware of this.
Yeah, it's a joke. And just Adam Abadi is supposed to be, they're supposed to be protecting and serving and being a prosecutor. And meanwhile, he's like representing Fannie in her own, discretions. And then he's coming in to show up to trash defense attorneys because they all trying to cover up the fact that everybody in that office knew that Mr. Melnick was in fact representing Copeland as it related to this case. Maybe he wasn't doing it a year ago when Adam had court with Judge Whitaker, but he was prior to this case and the prosecutors knew. Just saying.
So she goes on to say in this order, she goes, Copeland had the benefit of counsel. The predecessor judge did not on the whole, which I guess maybe on the part he did, but she says on the whole, he did not use intimidating. So how much intimidating rhetoric is appropriate? That's what I don't understand. Yeah. She apparently says that there's some intimidating rhetoric, but on the whole, Judge Glanville did not use intimidating rhetoric, but rather sought to ensure that Copeland understood the nuances of the decision he had to make. And he explained that many of the decisions about what could happen to Copeland were not his to make, but were up to prosecutors. Still, some of the information provided to Copeland might have been accurate. And Rachel, I want to get your thoughts on that. But before I do, let's have a look at this, because when I saw this video of the judge, well, let's just look at it. We'll come back. We'll talk about it.
Judge Glanville and Miss Love, correct?
What I'm saying is,
you answer the question that I am asking. You were in chambers with Miss Love and the judge and a court reporter, and y'all had conversations, correct?
Yes.
Okay. And you were aware prior to that morning that this case was being tried, correct?
Yes.
Okay. And you were aware that Miss Love was a member of the prosecution team, right?
Yes.
And that Judge Glanville was the presiding judge at the time?
Yes.
And that there were defense attorneys on the other side of the case, right?
Yes.
Okay. And so when you went into the meeting, you could see that there were no defense attorneys present, right?
No, but what I'm saying is, I didn't know I was going into a meeting.
Ma'am, I understand. Answer the question I asked.
Yes.
Okay. So at that point in time, you knew this is a meeting with the prosecution and the judge and no defense attorneys, right?
What I'm saying is,
ma'am, answer the question I am asking you.
I didn't realize it was a meeting.
Okay. So at the point when people started talking, let's call it a meeting at that point in time. Okay. And so you knew that the defense attorneys weren't there then, right?
Yes.
Okay. And so you knew it was an ex parte. If you knew the
All right, so that was, of course, Attorney Kayla Bumpus, who was Jonathan Melnick's, I guess, fill-in standby, or she was there to fill in for him because they made sure they timed all this so it coincided with his trip out of the country or something, long planned vacation that Melnick had. So when I saw this video the first time, look, judges, particularly judges who have experience in the courtroom, like Judge Whitaker does, they don't get to practice their cross-examination skills all that often. But sometimes when they do get the opportunity to, it's almost like they have fun with it. It looked to me like the judge was going after her quite aggressively, right? And my impression after seeing that, Rachel, was that she's probably going to be sympathetic and may grant these prosecutors' claims. But when I see that video, I just can't jive that with what I read in this order when she talks about here he had the benefit of counsel and all this other stuff. And that so everything that happened back there with Copeland, because he had a lawyer there, it didn't matter if the judge used entirely intimidating rhetoric, that maybe a little intimidation is okay. That's kind of what I take from this. And so it doesn't, I don't understand logically how she arrives at this order with this language in it, given what I've seen in court, like that video.
Yeah. I mean, it's factually, she's making findings that seem as though she should rule for the defense. However, she's finding ways to project the problem onto other people. So what I think was happening with Kayla Bumpus is it kind of became clear to the judge that Kayla Bumpus may not have understood at the time that she wasn't, I mean, whether or not it was an actual meeting or what it was, she may have not realized that that was not something that you're supposed to do. And the judge is trying to understand whether she allowed her client, who was not a defendant, to participate in this ex parte meeting, as though that's like relevant to her deciding whether or not the information provided by the prosecutors and Judge Glanville was inaccurate or threatening. I understand that it may be concerning to her that the representation that Copeland had may not have, I don't know, but how is it Kayla Bumpus's fault? It's not her fault. It's the prosecutor's fault and the judge's fault, but she's seeming to want to put it on Kayla Bumpus. Kayla can't waive the presence of the other defense attorneys.
That's true. She can't.
No,
that's the judge's job. That was Glanville's job.
Correct.
To make sure that this kind of thing didn't happen.
So she was focused on her because she was like annoyed that she wasn't answering the question as she wanted her to. And I don't think that Kayla, I think at the time she was trying to explain why she didn't realize it was an ex parte meeting. But either way, kind of like it didn't matter who told Brian Steele about the meeting. Those are projections and ways to avoid dealing with the actual issues in the case. And that's what these judges are good at doing, apparently.
All right. So she mentions in this footnote that Copeland's is been recalled into court. So let's take a look at just a brief minute of that.
I'm asking you now, when they're like, all right, we're calling Kenneth Copeland, are you going to say, okay, ask me what you want to ask me, I'll tell you whatever I'm going to tell you? Or are you going to say, nope, I don't care if you throw me in jail, I'm not saying a word, I am not getting on the stand?
It depends on how I wake up.
Okay. All right. Well, then we will just revisit it on Monday morning. So plan to be here at 8:45.
All right. So it depends on how he wakes up. And I guess we'll have to wait and see what happens. And it's look, and I understand, by the way, he's still represented by John Melnick. So I've got no concerns, honestly. I've got no concerns that Woody Copeland, Mr. Copeland, is getting good legal counsel. I mean, Melnick, as I understand it, this is based on what I've seen in open court, his big concern for his client is their grant of immunity was not broad enough, that it doesn't cover, there is no statute of limitations, as you mentioned, on murder. They can't grant immunity from federal prosecutions that Mr. Copeland might get into. So here, we just have to wait and see what happens. But to me, I mean, my advice, if it were my client, might still be to take the fifth, because these prosecutors can't give me what is needed to fully protect my client.
No, exactly. And, it's, again, ironic. It's more projection where the state is claiming that Copeland is being influenced and threatened by the defense. The implication is that they're being threatened by the defendants and the defense counsel. Meanwhile, it's the state and the judge telling him that he's going to be indefinitely in Fulton County Jail, 901 Rice Street, for as long as they can try all these other cases. So who's threatening who?
The end of her order here, she says, based on the comments in the ex parte transcript made by the predecessor. And by the way, so she looks at the transcript. If it were me, I would also listen to the audio recording, because the court reporter made one. They always make an audio, and they use it when they go back and make their transcript to make sure they get the transcript right. So if I were the judge, I would have also listened to the audio, because I would have, look, I mean, did the deputy sheriffs that were in that, did they have video? Because I would want to get the full context and the full flavor of what happened back there beyond just the transcript. But anyway, she says that she read the transcript based on the comments in that transcript made by Judge Glanville about the attorneys, both for the defendants and for witness Copeland, as well as his comment about outside agitators. The defendant asserts that the predecessor Judge Glanville during this conference revealed his partiality to the state. She says, pretermitting the questionable accurateness of the characterizations and or discussions, this issue has been mooted, in other words, rendered moot or irrelevant now, by the recusal of the judge from the case. All right, so the way I like to think about this, if I go rob a bank tomorrow morning and I get arrested at the end of the street leaving the bank, I can't just give the money back over and say, all right, you got me. No harm, no foul. No, that's just not how it works. If the prior judge was doing things that rendered the trial unfair to the point that it violated their due process rights, it can't be cured by the recusal of the judge. What am I missing?
What's problematic and that she isn't really taking into account is that in addition to the inappropriate ex parte meeting, that there's more like microaggressions throughout the entire trial before the jury that kind of point to the same concerns. That, again, to think that a jury is not affected by the way that the judge speaks to the defense versus the prosecutors, I mean, you'd be kidding yourself. And the fact that there's now a new judge in town doesn't change what had happened before. Like you said, yeah, you can't just give the money back. I've tried to make that argument, like with drugs, like no harm, no foul to the prosecutors. They don't really buy that. So they don't buy that then. So why should we buy it now?
All right. So Doug and the others who filed motions for mistrial, they've all been now denied, and we're going to be back in court. And I think by my math, it's been about 8 weeks, more or less, since the jury in this case has been inside that courtroom. There was this 4 or 5 days that they actually had court where the jury was in the courtroom hearing testimony between the time when Judge Glanville should have sent the motion to recuse to another judge to rule on, and when he actually did so, because the law says that he's supposed to stop immediately and send it to another court immediately, but he didn't do that.
No.
He didn't pause. He went on for a couple of weeks and had several days where the jury was there. So the judge has said that they're basically going to have to get the jury to forget about that. In other words, unring the bell, put the toothpaste back in the tube. And the other one is like, you say you can't get the skunk out of a jury box. You can't, because once you move the animal, the odor is still there, right? And so she's going to ask this jury to do just that, to disregard Copeland's testimony on those several days. So the question is, Rachel, what happens if the jurors come back and they say, no, we can't?
Well, so the jurors, any juror that responds to this limiting instruction or curative that she's going to read to them, if any of them say that they're unable to put it aside, she's going to have to release them from jury duty, and she's going to have to call in one of the alternates that have been sitting there, which is my understanding there may only be 4 of them left. I
was texting with Doug earlier. I think Whitaker said that if 8 jurors cannot put Copeland's testimony aside, but with only 16 left on the jury, by my count, right?
Yeah,
it would wouldn't it be losing 5 that you can lose, because you can't get below 12 in a criminal case in Georgia. It's got to be 12 jurors. And by the way, you can't do the rest of this trial, even if you do it on the expert, you can't do this trial without any alternates. So if you remove more than 5, you're down to you're down below 12. So that's as many jurors as they can possibly excuse. And even doing that, I don't know how you move forward without alternates.
Yes. So that's the math that I agreed with. I mean, I feel like if 5 of the current jurors say that they can't serve, then you're going to end up with, the 4 alternates on, but you're still just getting 11. And I guess unless all the parties, which they're not going to, agree to go forward with only 11, I don't think you can go forward with less than 11. I don't know why any defense attorney would waive that.
No, you would never waive that.
Or the state probably wouldn't waive
malpractice.
Yeah. But I wanted to say, so yesterday in the paper, but almost every single day on the cover of our Atlanta Journal-Constitution, which is the main paper in Atlanta, the headlines are all about this. They're about Fonnie Willis's office and Fonnie being investigated for fraud, about the judge being recused from the case, about the prosecutor being, having to go back to prosecutor training, but still being allowed to continue with the case. It's everywhere. And so the idea that, the jurors, I don't know if she's going to individually poll each of them. There's just no way. There's just no way that less than 5 of these jurors have been unaffected.
But anyway, so she's going to have to figure out who on this jury has, is going to be able to disregard Woody's testimony on those days. And if she excuses too many, then that would be a mistrial. And that kind of mistrial, by the way, because I know people are going to ask, that would not be with prejudice. If there's a mistrial, at least I think that's how she would rule. If she has to excuse enough jurors so that they don't have enough, then they would have to mistry the case. I could make the argument that mistrial would be because of illegal and improper actions taken by the state, and I would include Judge Glanville in that because he's part of the government. And so I would say that if we had 2 weeks that occurred of this court with the jury in the courtroom that should never have occurred, and now we're asking the jury to forget about everything they saw and heard on those days, I could make the argument that should be with prejudice, but I think she would grant a mistrial without prejudice. But what do you think?
No, I think the same. I think she'll do anything to allow the case to keep going. There's some judges in Fulton County that I think are not as invested in the opinions of the other Superior Court judges and would be so annoyed with the state that they would have the, the gall to tell them enough's enough and we're done with this. And it's with prejudice. But I do think this judge, in the way that she'll find any, it's just a little bit threatening. It's not all threatening. She'll find any way to flip it around so that the jury can still be there. But again, any juror, even if they, can in their minds disregard what happened 8 weeks ago and they don't even remember what happened, I mean, now would be a very good time for them to say, I can't put it aside and get out of there.
All right. Well, we'll just have to watch that closely and see how it all plays out. But now look, there's something else big that happened this week that, let's circle back to the Brady issue. Let's take a look at this video real quick, and then it's a replay of what I did at the beginning, but it's going to be relevant to what I want to talk about next.
May I step to the door once more?
Yeah, and let me, before you step to the door, is there at this stage, which is mid-trial, anything else, whether Brady or not, that you think might be relevant to either the state or the defense in trying this case that you, the state, know of that the defense still does not know of? And you may want to huddle with whomever comprises your team, and y'all all put heads together and really, really, really think about that, and then get me an answer after lunch. Okay.
All right. So what that was, look, and we now know, I think conclusively, that this judge's bark is worse than her bite, because she basically did nothing except she made a token gesture about what to do about what she believes are negligent discovery violations, I guess, and that maybe includes Brady. So she's got a proposed remedy, Rachel. She says, I'm going to cover up part of our face for a second. She says, this court therefore orders as a remedial measure. So this is a remedy, right? The entire prosecution team working this trial submit to training on Brady and other professional obligations of a prosecutor. That's her remedy. Okay, so she's sending, well, first off, who is the prosecution team? Well, it's obviously the lawyers we see in court, but I think that it includes Willis herself, because in any lawyer who's filed any pleadings in the case, and maybe if Adam Abadi testified, maybe he's part of the team too, because he's in one of the senior management positions down there. So I think the team has to include the captain of the team. So what kind of training do you think, Rachel, would satisfy that judge's order?
She should have been more clear. Probably an hour of professionalism training at the prosecutor camp taught by prosecutors. I've always said I would love to go to this prosecutor camp over the summer, and I would love to teach ethics and professionalism to them. Allowing these people to get off by telling them to go, take a class and training. No, they have to be punished so they don't do it again. They know what the rules are. They don't care about breaking them. That's the thing, is that she's acting like they don't know what they're doing. That's not what's happening. It's that they choose to ignore their professional duties and ethics and do whatever they want to do. And she's basically saying, you can do that. Just take another hour of training.
Yeah. All right. So here inside the law, we are about learning about the realities of how this works. The reality is that all lawyers, including me and you, have to do ethics and professionalism training every year as part of our continuing legal education requirements. We have to do it. And if we don't do it, we can get our license suspended or whatever. We wouldn't be able to practice. So this seems to me, this order to do remedial Brady training seems to be, well, it doesn't seem to mean much to me, because hell, they got to do it anyway. I mean,
they have to do it anyway. And what would a proper remedy be? Disqualifying them, reporting them to the bar, not just threatening to do it. When Adrian said, can I step to the door? It's like, yeah, you can stay there. You should stay there. something
the
like
judge's
that.
order mentioned the other professional responsibilities of a prosecutor. They're different, by the way. Prosecutors have something. I'm gonna let you tell it what it is. Prosecutors have something different than the rest of all the other lawyers. Okay, they have something extra that is unique to prosecutors that doesn't apply to any. What is that, Rachel?
Well, there's special duties of a prosecutor under our rules of professionalism in Georgia. And the gist of that is basically that the understanding that we give them so much power, and that their job is not to seek a conviction or win, but to actually seek justice. And justice may mean something other than them getting a conviction, which is why when prosecutors campaign on conviction rates and stuff, it's so dangerous, because the truth is that that's not what they're supposed to be doing. And if that's what they're focused on, then they're not focused on abiding by and complying with their special duties as a prosecutor.
I talked earlier at the beginning of the show about a big case that I've been working on, a real serious case. I've been working on it for a couple of years now, and we were able to get it resolved because prosecutors came forward with some Brady material, and it allowed us to reach a fair compromise. And one of the prosecutors said something to me in the whole process. They're like, "Look, I think this is a just result." And that's but it wasn't the original charge. It was significantly reduced. And I think that prosecutor was correct. I think in the whole scheme of things, it was just, and I appreciate that prosecutor making that comment in that way, because it reflects this additional ethical requirement. And by the way, go ahead.
No, how I know Adrian, this is not new for her, that this is not an accident, is because I have a case, not the case that I've talked a lot about Shane Kendall, where she did some horrible, horrible, unethical things. But I have another case that's currently pending on appeal. Brian Steele is handling the appeal. I was the trial attorney. It was a specially set trial. My client had been sitting in a Fulton County jail for several years. And so we were supposed to be going to trial on the morning that we were picking the jury, and I was trying the case by myself. I didn't have the benefit of several other lawyers working on the case, and I knew it wasn't going to be long enough, and I will regret this forever. But she provided us with a new statement by one of the witnesses, where the witness completely changes what they said about who did it. And then, we have Adrian and another investigator laughing with this guy, telling him that they'll try to get him housing, and they'll try to get him all these things, and they'll try to help him. I was so busy trying to pick a jury and try the case that I was stunned that the day before trial, actually the opening statements start while we're picking a jury and swearing in the jury. She's providing, well, in this case, it wasn't Brady material, but it was evidence that I would have needed to prepare for, and that looking back, I should have asked for a continuance, but it was specially set so long, I couldn't have imagined at that point a prosecutor kind of sneaking up and changing the entire case last minute. The co-defendant's lawyer benefited from this, so they didn't tell me either. But it's just the tactics have been absolutely disgusting by her the whole time. So it's not just Brady, it's that there's other discovery. You have to make defense attorneys have the right to discovery such that they can prepare a defense.
But you mentioned the discovery rules. In Georgia, we have what's called reciprocal discovery. They got to give us everything they've got, more or less. And we have to give them certain things, particularly if we're going to use them. That's why it's reciprocal. It goes both ways. But the law says they don't have to give it to you until 10 days before trial. We've got to change that because, as a practical matter, prosecutors and most judges will require them to give it to you sooner than that. 10 days before trial, before you start picking it, is ridiculous. There's no way to adequately prepare for any kind of case, in just 10 days. That's just not adequate. So we got to change our discovery. And we also, in Georgia, we need to have depositions in criminal cases. It's not good enough that I can question somebody if we have a car crash. I can make them, through a subpoena, come to a lawyer's office and answer questions about a car crash when all we're arguing about is how much money somebody's going to get. It doesn't make sense that we can have depositions in that context, but in preparing to save a client's, maybe their life, certainly their freedom, we don't have the ability to do that. And oftentimes we don't know what the prosecutor is going to have them say until there's a jury in the box.
Yeah.
They don't have to talk to. We can call and ask them, hey, what are you going to say? But they can tell us to go pound sand. They don't have to talk to us.
Many of the prosecutors and their staff inform a lot of their witnesses and alleged victims to not speak to defense attorneys
routinely. Yes,
routinely. So, but the issue, like you're saying about the 10 days prior to trial. So how is the judge suggesting to Adrienne Love, however many months in we're at now, she's suggesting to them, have you turned over everything? Those 10 days before trial, that ship has sailed. How could allowing them to bring in any evidence that they haven't turned over at this point, I think is a great appellate issue, because that's not fair. How can I prepare in the middle of trial?
Well, as you know, when we're constantly, things, it's very dynamic and fluid, and we're constantly researching stuff, checking our file for stuff. There's a lot going on. So you got to have a lot of advanced preparation. You got to be able to work with the material.